Good evening, everybody, and thank you for joining us for this March edition of Alabama Workers' Rights Training. My name is Larry Hodge. I'm Community Engagement Coordinator for Jobs to Move America's Alabama's team. Joining me today, as always, my partner in, well, not crime, but my cohort, Charles Crooms, lead organizer for Jobs to Move America. And today we have Lauren doing her solo run. And she's Lauren is the staff attorney for A Better Balance, and Lauren is going to be able to help us help you understand your rights to a safe workplace. And we're going to go ahead and get started, but I do want to thank everybody for joining and apologize. Last week I had a family emergency, so I had to cancel that session, and I want to thank my partners for working with me and being so flexible and helping to bring this one to fruition. We're going to go ahead and get started today. Today, our topic is what causes workplace injury, illness, and stress. And I'm going to try and use my years of experience in safety training to help you understand that it's not the workers, okay? And we did a training back in October, I think it was, called Blame the Worker Safety Program. And it explained to you how most safety programs actually blame the worker when they're injured, when it's not the worker's fault, but we're going to get into that now. So as always, we want to remind you that this training is brought to you in partnership by the Alabama Coalition for Community Benefits, which consists of the American Federation of Labor, Congress, excuse me, I have to turn this off, Congress of Industrial Workers, the AFL-CIO, National Black Workers Center Project, Adelante, Alabama Workers Center, A Better Balance, and also Jobs to Move America, to name a few. It is really an organization or a coalition of a lot of nonprofits and other agencies all coming together under one umbrella to try and change things, make it better for people, and in social and economic justice for workers. So Alabama Workers' Rights Training. Again, oftentimes we'll work on jobs where management will try to blame everything and everyone for the injury except the real perpetrator, and that is hazards. What causes injuries, illness, and stress? Hazards cause injuries. Once we eliminate the hazard, we eliminate the risk of people being injured on the job and even killed. There are types of programs like the Blame the Worker programs that will, in every case, and I've worked under them, you will be blamed for it. But today we're going to let you know that you're not the cause of it. You are the solution. You're the reason it's going to stop. Excuse me. Our agenda today, of course, welcome and thanking you for being here. We're going to go into types of safety hazards to start with. Work organization and how it contributes to hazards, and also how it can also be the cause of us eradicating them. We're going to do a case study from an actual OSHA accident or incident that happened on the job, and it actually cost this young man this man his life. And then we're going to talk about your rights to a safe workplace. And we're going to have our closing and remarks and our thank yous. You know, and a little bit about me. Again, I'm Larry Hodge. I'm a Community Engagement Coordinator, and I've worked in the state of Alabama for 40 years. I'm originally from Birmingham, and my background is in manufacturing and construction. I worked in the manufacturing and steel mills of Birmingham many years ago when I was a much younger man. And but once I got into the construction industry, I was in a really dangerous job, scaffolding. And it's a really hard job, and you know, it's really physically demanding. And I found out that it was taking a toll on my body. So that's when I started to really take heed and notice what a real safety program, how it could help me. And so I got involved in safety committees and which led me to where I am today. And so we want to go ahead and get started. But number one, I want to help you and not make the same mistakes that I did. You know, I like to say that I earned my scars so you don't have to. Scope of this training, the purpose of it is to familiarize you with the true causes of workplace injury, illness, and stress. And in this training module, we want you to learn first and foremost how to recognize safety hazards. If you don't recognize them, there's nothing you can do to protect yourself against them. And we also want to show you how to protect you and your coworkers by forming worker safety committees. Very important to work in numbers, work in groups, and you have a right to do so. And that's one of the things that Lauren is going to be able to help explain to you. And again, your rights to a safe workplace. The best way to control hazards is to get rid of them, okay? First, now we're going to go into some of the hazards that exist on jobs, and especially in the manufacturing industry. Chemical and dust hazards. And that could be anything from cleaning products, pesticides, asbestos, silica, in many cases, in many applications on certain jobs, and things such as that. You also have biological hazards, mold, insects, pests, communicable diseases, and so forth, ergonomic hazards. And I happen to know a lot about that. I have the scars to show for it, as I said earlier. And that comes from repetition, lifting, and especially in awkward positions and awkward postures and so forth. Safety hazards, slips, trips, and falls. Oftentimes that's as simple as good housekeeping can be adhered to in order to eliminate that. So that's one we're going to look at, because oftentimes many injuries on the job is caused by simple bad housekeeping. And we have physical hazards. That would be noise, temperature extremes, radiation, and so forth. And finally, we're going to talk about work organization and how the way the work is organized can contribute to the risk of you having accidents and illness and even stress on your job. So we're going to go with safety hazards first, okay? And as I said, it's the most common of hazards, and they're present in all workplaces, to be honest. And it includes unsafe conditions that can cause injury, illness, and death if not adhered to, if not taken care of. This could be anything from spills on the floors or tripping hazards, working from heights, unguarded machinery and moving machinery parts, working from heights. And this is why it's so important to have a safety program in place. We'll take working from heights, for instance. There was an incident where this bus manufacturer, they had OSHA called to do an inspection by one of the workers. And although they were there for that particular hazard that was reported, they also, during the investigation, they found that workers were being made to, they had to work atop a bus, and there was no fall protection, there was no guard railing or anything to protect them from a fall to the lower level. So one of the things OSHA did in that case was that they brought charges and they fined the company for that. And also they made them correct that hazard. And today, as a result of that, they have a platform with handrail systems that they are pushed up against the bus, and the people up top can walk around freely and don't have to worry about falling. And that's one of the real hazards. Me coming from the scaffold industry, I can tell you, falling from heights is one of the main killers in the workforce. Unguarded machinery and moving machinery parts. Again, I've worked around these armatures and these huge shafts that are spinning at, seems like the speed of light. And, you know, they'll be In some cases, they'll have signs up or they instruct you not to wear loose clothing or not to wear jewelry that hangs that can get caught up in it. When the real safeguard against that would be to add guards around that so your loose clothing couldn't get caught up in there. You see, that's where we want to make sure that you understand that you're not the cause of injury. It's oftentimes the company and the way that they perform the work or have you perform the work that really puts you at risk. Continued, we're going to talk about electrical hazards. And that could be anything from frayed cords, missing ground pins, improper wiring, and so forth. And so last job I worked on, and I'm a carpenter, so there were times, not, it didn't happen all the time. There were times that my electric cord would get caught up in my saw and we would cut it. So normally what people would do is just simply take it and, twist the wires back together, put electrical tape on it and keep going. But that is not the safe way to do it because you still run a risk at that point of being shocked. So one of the things we had to do, one of the safety protocols were that you would take that saw out of commission. You either take it to the mechanics or who work in the tool area, and they would install a new cord on that. So you eliminate the hazard, not cover it up or and so forth. So those are the things that a real safety program would have done in that case. Confined spaces. Confined spaces are always a huge hazard. There was a young man up in Huntsville last year in the state of Alabama. 5 people were killed on the job in less than a month, okay? This man was sent into a trench and they didn't have the proper safety protocols in place. And the trench collapsed and it killed him. And there were 2 other guys that were in it at the time, but they were able to save them. And so that is a confined space issue that could have easily been dealt with had they put what we call trench boxes in that trench, and it would have prevented that trench from collapsing and saved that man's life. So a safety program, again, it wasn't him that caused that. It was the conditions that he was being made to work under, which caused his death. Machinery related hazards such as lockout, tag out. That's where you would have to work on a specific piece of equipment. In a lockout, tag out scenario, you would make sure that whatever the energizing force, whether it be air, whether it be electricity, whether it be hydraulics, whatever it is that energizes that system, you would make sure that that switch was in the off position. There was a lock preventing it from physically being turned on. And everyone that had to work near that piece of equipment would have a lock, and they would put it on a box where that original key is located and lock that box out. And that way, no one could turn that piece of equipment on while they were working in that area. The only way you could turn it back on is once everyone removed their locks from the box. It's called a lockout tag out system. And I want to encourage you, if it's not in place on your job, that's where forming a worker safety committee is so important. You can come together and go to management and make sure that that is put in place, because that causes lives and it could save your life. Biological hazards associated with working with animals, people, infectious plant materials, such as working in schools, daycare facilities. We have kids know that those are little walking germs. And so all of those things fall upon the biological hazards. When you're talking about types of things that you might be exposed to, would be blood and other bodily fluids, fungi, mold, bacteria, and viruses. And I remember working in the construction site in these plants, you know, here in the South, you got a lot of guys that dip and they walk around spitting everywhere. And they actually made them start walking around with a bottle, and that way you don't spit everywhere and everyone is exposed to your bodily fluids. You know, things such as that. That was a safety program in action. Something that you might not think about, but it was done in order to protect workers from being exposed to these type things. Workplace hazards continued, physical hazards, ergonomic hazards, chemical hazards. Physical hazards are factors within the environment that can harm your body without necessarily touching you. So it's things like radiation, including ionizing, non-ionizing, microwave, high exposure to sunlight, for instance. We worked in construction. There's a high incident of workers with skin cancer. And it's because they're being exposed to the sun rays constantly for so many years and this type thing. Hot and cold. I worked on jobs that were so cold, you thought it was against the law for them to have you out there. Ergonomic hazards. And these hazards occur when the type of work, your body position, and working conditions put strain on your body. A little later, when we go into an organization, we're going to talk about it, and they have a name for it. So they're the hardest to spot because you don't always immediately notice the strain, but they can come from anything. Short-term exposure may result in just, you know, sore muscles the next day and so forth. Long-term can lead to real joint issues, and I personally know a lot about that, as I've had to have 5, yes, counting 5 surgeries, and it's a direct result of the type of work that I used to do. Chemical hazards. Now, they are present when a worker is exposed to any chemical preparation in the workplace. They can be solid, liquid, or gas, and some are safer than others, but to some workers who are more sensitive to chemicals, even common solutions like cleaning supplies or cleaning liquids can cause them real problems. So that's something to keep in mind, and knowing your body and knowing that what you are capable or can withstand. You want to make sure that you have this, that you're aware of all of this when you're working with chemicals. Some of them, you know, especially if chemicals are unlabeled, they're coming in a container that's unlabeled. There is it's called HAZCOM, Hazard Communications, on a job where each employer is required by law to reveal to or let you know exactly and give you all the information on the specific chemicals that you are exposed to on that job. Okay, so that's something, another thing that people, I don't know if everyone knows it, but it's something that's really valuable for you to know. Work organization hazards. Now, work organization has hazards or stressors that cause stress, short-term effects, and strain, long-term effects, what we just talked about. Now, these are hazards that are associated with workplace issues, such as workload, lack of control, or respect causes the stressors on your job. Examples of organization hazards include workload demands, workplace violence, intensity, or pace, and that's a direct result of what I had to go through and why I had to have all these surgeries. It has a lot to do with the pace that we are oftentimes are demanded that we work under. So, you know, we've already identified the fact that hazards is what causes your injuries. And when considering how to eliminate work organization hazards, it's really important to have some safety committees in place. And that's where workers have a voice, and you're able to work with the company in order to deal with these, because the company is what organizes the work. And if there's just a one-sided relationship right there, you have no say-so in the matter. And oftentimes when you do it alone, yes, you don't have the strength, but once you bring your co-workers together, you have power And again, we're going to go into your legal rights to do these type things. So overwork and work organization. This is a hazard to worker safety and health. And there's been a lot of concern about increased workloads causing or contributing to injury, illness, and stress in the workplace, and things such as combined jobs, multitasking, electronic performance monitoring, and commuting. That's one of the things that was really huge in the workers' issues at the Amazon plant out there, is everything was done via electronic performance monitoring. You have all these insane quotas that you have to wake. And in fact, there's charges being filed against them right now as we speak. Use of temporary workers, people who might not be familiar with the job that you're doing, that causes a lot of problems on the job as well, because they don't have the training that's necessary. Alternative work schedules, all examples of work organization that can hurt workers. Now, they're being introduced with very little attention to their potential to increase the risk of injury, illness, and stress. And, you know, we're not robots. We're human beings, and we cannot keep up the pace and productivity of some of these insane quotas that demand that you work like a machine. And without causing serious physical harm to yourself, there's just no way you can keep up with it. Forms of work organization that increase your risk. Things such as the pace of work, again, the speed of an assembly line and the quota. So you're having to keep up with an assembly line that's being controlled by a machine. And it's just oftentimes they don't take into consideration that we have someone raise the hand in the, if you would, please put your question into chat, Jamie, if you could. And one of the other co-hosts can attend to that. If you don't mind, just let me know. But as we, so staffing levels, workloads, number of people performing the job, all of these, you know, it seems that as though they want to do the most work with the least amount of people possible. And in turn, that puts way too much stress on an individual. Hours and days on the job, that is another one. I've worked on jobs where there was this mandatory overtime that we had to, you have to be on the job for. And when you're being expected to work 7 days a week, 12, 13 hours a day, at some point, you simply become a walking hazard, just a, you know, on the job site fatality waiting to happen. We had guys one morning on the way to work, they got within 1/8 of a mile of the plant. I mean, maybe even closer than that. And he rolled the truck, you know, and these kind of things happen quite often. And there's not nearly enough talk about it. There's not, the public seem to not be aware that these are the type of things that are happening. And that's what we're here to do, is to amplify this and make sure that people understand what goes on. Lack of rest breaks and days away from the job. Again, those two can be closely associated, because what happens is that your body, if you're working these long hours consistently, this physically demanding job, your body does not have time to recover or heal from yesterday's or the days before, that damage that has been done. Anybody that has done, that has worked out and did bodybuilding and so forth, they know that you'll work out hard, you get those muscles, they're sore, they're stretched, and you might take tomorrow off or 2 days off in order for your muscles to recover from that type thing. But when you've been working under these type conditions, there are no days off in order to for your body to recover. Look at assignment of tasks and responsibilities. Oftentimes they put people in jobs, again, take the temp workers, for instance. They'll put a person in a job that they're not trained for, that they're not skilled in, and it causes problems. It increases their risk for having accidents on the job. Training for the task being performed. Again, if you don't know and you're illy trained and not properly trained for a job, that is something that increase your risk of physical harm to yourself or someone else. Has anyone want to talk about the question that was asked, or shall we continue? We'll continue.
Oh, Charles. Oh, Charles, are you?
Yeah, Larry, I was gonna say we can continue. Jamie just
Okay.
she typed in a comment.
Okay. Oh, just a comment. Okay. If you want to talk about it, we can, surely.
Her comment was unrealistic expectations and workloads. In
Yes.
addition to what you were listing.
Great. She should be on this side of this thing. That's perfect. Excellent. That's exactly unrealistic. It's what's expected of us, and that increases your chances of being injured on the job. Okay. First, I talked a little bit about a mandatory overtime and how it affects you. Long work hours, mandatory overtime, increased workloads, inadequate work cycles, long hours, and job burnout. And as a result, a worker may experience increase in blood pressure and higher risk of heart attack. So these are the things that we don't take into consideration. How this temporary assignment can cause us long-term, oftentimes lifelong problems, and it can contribute to our early death, actually. Increase of blood pressure and higher risk of heart attack, work-related musculoskeletal disorders. That's the name that I was talking about when I said we were going to talk. They had a name for this under the ergonomic portion that we talked about. It's called work-related musculoskeletal disorders. And again, without getting too graphic, I have so much titanium in my body that is unbelievable. I know I am really fortunate to be able to, continue and function the way I do. But, and it's a direct result of the type of work that I did and the expectations, the unrealistic expectations that were placed on me. It influences your mental well-being at home and at work. And we've all seen news reports of people, workplace violence, where people seem to snap or whatever. Oftentimes, this is a direct result of the pressures that they're experiencing on the job. This is the part that no one wants to talk about. I'm not promoting violence in any way, but there's always reasons, and these are the things that we need to probably take into consideration before it reaches that point. You see. Now, long hours and job burnout. Again, we talked a little bit about that. In addition to the effect work reorganization has on the worker's physical health, studies also show that many of the impacts of organizational changes are also key factors that influence mental health. We're talking about it: job burnout, stress, poor work-life balance. Thank you, JMA, for allowing us to have a healthy work-life balance. And presenteeism is what it's called. And it's explained to us at the Tony Mazzocchi Center as being, you've gone to work, you were present, but you know that everything about the way you were feeling indicated that you should be at home and not at work. Well, oftentimes, certain jobs, when you go to work in that state, oftentimes have more serious consequences than others, although it's not good anytime, but that's something to think about, working while you're sick. All of these can influence a person's mental well-being at work and at home. And when unrecognized, mental illness can lead to substance abuse disorders, increased violence, both at work and at home, and even suicide. And we're going to take a look now at a real life case study. that we talked about a little earlier, and it comes from an OSHA website. Now, this incident involves a roofing worker, and it is going to walk us through an incident involving heat stroke, actually. Okay? Now, the following related case study is a result from an OSHA enforcement investigation. And let's look at this. Some of the names and such has been changed, or the details, in order to protect the privacy of the workers. So in July, a 42-year-old man started his new roofing job. Now, his employer did not have a formal plan to protect new workers from heat-related illness, although there was water, ice, and Gatorade available to the workers on the work site. Now, the worker felt fine the first 2 days on the job. The third day was a little warm and the temps was around 86. Now, that afternoon, he told his coworker that he felt hot and sick. He climbed down from the roof and went to sit by himself in the sun. And when his coworker checked on him a few minutes later, he saw that he was experiencing symptoms of heat stroke. He was taken to the hospital and this man died. We're going to take a look at a couple of things that possibly contributed to that. And certainly it should be known. And I chose this one because it's about to be, get the season, it's changed and it's going to be hot again. And I've worked in situations when I've actually experienced heat stress related illnesses. So I know how dangerous it can be, and I also know how it affects your body for the rest of your life. Now, some of the personal risk factors, you got to be aware of them. People with certain medical conditions, and I don't know what this person's medical history was, but these are some of the things that we all need to take into consideration. Pregnant people, lack of physical fitness, previous episodes of heat illness. And I can tell you, I am living proof that once you overheat to the point of heat exhaustion or heat stroke, your body will never be the same again, and you'll never be able to reach that temperature again. Take it from me. If you haven't done it, do everything you can to make sure that you don't. Alcohol consumption is a big one, okay? Drugs and the use of certain medications also contribute. Now, although employers have a general duty to protect all workers from known hazards and unsafe conditions, being pregnant may face unique risks that may be more susceptible to a range of serious workplace hazards. Also, certain medical illnesses, lack of physical fitness, previous episodes of heat, all of that, they're huge in terms of how your body reacts to being exposed to heat. How to recognize heat-related illness. Now, although there wasn't a plan in place, it seems as though his coworker did have some knowledge of what the symptoms of a heat stress or heat stroke were. And that's why he was able to tell him. But there were certain things we're going to go over later that they got wrong, that never should happen. But so to recognize heat-related illnesses, anytime an individual present, symptoms of confusion, slurred speech, I don't know why they have unconsciousness in here, because once the individual is unconscious, there's no more guessing as to whether or not they are in a medical emergency. Seizures, heavy sweating, a hot, dry skin. And in the field and construction, they often say too that once you stop sweating, you're in a really bad situation. Very high body temperature, rapid heart rate. Employers and workers should be familiar with heat symptoms. And whenever any of these symptoms are present, don't try to diagnose which illness might be going on, because you can suffer from a combination of heat illnesses, heat stress, and heat stroke, heat exhaustion, heat stress, and heat stroke. So it's not important that you try to identify which one it is. Diagnosis is really difficult because the symptoms can occur simultaneously, and also they can change very quickly. So action at any point that a person starts to exhibit any symptom of heat-related illness we need to start trying to get them their body temperature down. Case study recap, lessons to be learned. One is protect new workers during the first 2 weeks on the job. Make sure that they have plenty of rest breaks and drink enough fluids. If you remember, this guy was only on the job for 3 days when this happened to him. And I can tell you from experience again, that once you start to be in these situations where the temperatures are increasing, you know, coming out of the fall or the winter months, your body is not acclimated to that heat, okay? And what we were trained in this several times a year to make sure that not only the new worker, but everyone on the job made sure to pay attention to themselves as you become acclimated to the heat, because at first you're not, and you are very susceptible to heat-related illness, okay? Never, I repeat, never leave workers alone. If you remember, his co-worker saw that he was hot, told him to come down and go sit down. A couple of things went wrong there. So number one, you never leave a person alone in that case. Their condition can worsen very quickly, and they should be taken to a cool place, not sitting in the sun, provided first aid, and immediately the slightest delay can, and I mean, you need to do this immediately, because the slightest delay could cause that person their lives. Who was on the job one night working up against the boiler, and I mean, it is just what it sounds like 140, 150 degrees, and we had to have on Tyvek suits, full face respirators. So you can imagine that it was unbearable. So me knowing that I had overheated before and I'm real familiar with the symptoms, I knew it was time for me to come out. Okay, so as I come out, I'm taking off my gear, but I'm noticing this young man sitting there. And as soon as I looked at him, I knew he was in more trouble than I was. And Charles, it was the guy that went to the rally with us, actually. And as soon as I saw him, I knew. So I took him to a cool spot, got him out of all of that stuff, took these rags, paper towels, and ran cold water on him and put them around his neck and up in his chest area to start bringing his core temperature down. On the job, they gave us these electrolyte replacement little freeze pops. Those things saved our lives sometimes, but I made sure that he got 1 or 2 of those in him and started to drink water, and his body temperature slowly came down. And it possibly did save him from a really, really serious heat episode, if not worse. So, you know, knowing these things can really help you and your coworkers. So it's really important. And you remember, temperatures don't have to be extremely hot. So we working in 150 degree temperatures, but it doesn't have to be that hot. This man, temperatures was around 86 and he died, okay? Because temperatures in the 80s can easily create heat indexes in the 90s, which in this case is proof that it can kill you. So that is one of the case studies that we wanted to talk about. And I hope it did help you understand just how important it is to, number one, be able to recognize hazards, number one, and to be trained in what is necessary for you to protect yourself and your coworkers in these incidents, okay? I'm gonna go ahead and turn it over now to Lauren. I do wanna thank you for participating. And if you have any questions, please feel free to put them in chat. If you have any questions for Lauren and Charles and during this next portion of the training, please don't hesitate to ask. And I'm going to turn it over to Lauren. Again, she's a staff attorney for A Better Balance, and she's going to tell you about your rights to a safe workplace and how to enforce them and how you may be protected from unsafe working conditions. Thank you, and Lauren.
Lauren, you're muted.
Thank you. Still getting used to Zoom even after all this time. Thank you, Larry. Thank you, Charles, for that. As Larry said, my name is Lauren Booth. I am a staff attorney with A Better Balance. A Better Balance, we're a legal nonprofit organization that we use the power of the law to advance justice for workers so that they can care for themselves and their loved ones without jeopardizing their economic security. I'm personally based in Montgomery, Alabama, and we have a southern office right in Nashville, Tennessee. We also offer a free and confidential legal helpline. So if any of the laws that I'm discussing today, if those are kind of bringing up some issues that you've had or instances where you know that your rights have been violated, you can always give us a call at 1-833-NEED-ABB. This helpline is going to be at the end as well. So no need to hurry up and rush and write it down right now. Okay, next slide. So just quickly, we don't have time, of course, for full length legal training. So we're just kind of going to give kind of some of the highlights on one, OSHA, the organization that's kind of responsible for your right to a safe workplace. And, Larry's mentioned that a couple times earlier. And then after that, we're going to go into 3 of the federal laws that could protect you or help you in situations where maybe you have been injured on the job or there is some sort of some sort of illness or injury that is affecting your work. So that's kind of how I've broken it down. Next slide. So first, we're going to start with OSHA. OSHA, it's the Occupational Safety and Health Administration. It was created by the Occupational Safety and Health Act, OSH Act, signed in 1970. Under OSHA, you are entitled to a safe and healthful workplace, free of known dangers. You are entitled to training in a clear language that you can understand about your hazards, methods to prevent harm, and that know that OSHA rules are to apply to your workplace. You also are entitled to tools and equipment to do your job safely. This includes PPE, personal protective equipment. We all know of this from like COVID, masks and stuff like that, but you've always had that right, free of charge, you've righted that. You also are entitled to receive information about the chemicals, hazardous chemicals in your workplace, and obtain access to safety and accident reports that the employer is required to keep. If these risks, if you do find that these hazards are to be in place, you are entitled to try to speak with your employer. In the next slide, I go through the steps. You're entitled to kind of speak with your employer or supervisor, try to correct the hazard if you see the hazard. And then if they fail to correct the hazard, you can contact OSHA as far as enforcement. They have OSHA, you can file a whistleblower complaint within 30 days. If you think that you called OSHA and then they retaliated against you in some way, maybe they fired you or demoted you, cut your hours and stuff like that. So you're also protected from retaliation as well. Again, if you're seeing these hazards, you try to speak to your supervisor, they're not correcting it, you are entitled to contact OSHA for them to review the work site. And the contact information for OSHA is 1-800-321-OSHA, and more information can be found at osha.gov. So that was just a quick recap of OSHA, not having too much time to get into it. And then the next slide here, I want to start off with a little scenario, and then we'll get into the law. For the last 3 weeks, John, who has a psychiatric disability, has been working 40-hour work weeks at a big manufacturing plant in Alabama. As a result, he has been experiencing a high degree of mental stress to the point that he's no longer sleeping or eating, which is affecting his health and his ability to come into work on time. Are there any changes John can ask for in the workplace to stay healthy while working? Okay. So This kind of leads us to one of the laws that could assist John in this situation is ADA, or the Americans with Disabilities Act. The ADA applies to employers with 15 or more employees. We know he works at a large manufacturing plant, so we can assume here that there's more than 15 employees. And it makes it illegal for employers to discriminate against workers with disabilities, as well as requires an employer to provide reasonable accommodation. These are minor job changes to the employee with a qualified medical condition, unless it would impose an undue hardship. What that simply means is that they're required to kind of give you these assistant or minor job changes unless it'd be too expensive or difficult for the company. And you must be able to complete the basic duties of your jobs with those changes. Next slide. Under the ADA, a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. That includes performing manual tasks. So it limits your abilities to lift. So you need assistance lifting. Seeing, hearing, eating, sleeping. Sleeping, like in John, he's not able to sleep. It's affecting his ability to, do his tasks that he has to do. It may be needing to have a snack if you have high, low blood sugar to keep your level stable. Speaking and breathing, maybe you have severe asthma. Learning, reading, concentrating, that could be something like ADHD, or you have trouble processing, so you need things to be written down. And under the ADA, it's also going to cover pregnancy-related illnesses, not pregnancy itself, but those diseases that can accompany pregnancy, like preeclampsia, which is high blood pressure that develops during pregnancy in women, gestational diabetes, or severe morning sickness. Those are some types of disabilities that are qualified under the ADA as a disability. Under the next slide, just going to quickly go over, we talked about John having a psychiatric illness, and so the ADA does cover mental health conditions. So depression, PTSD, other severe mental health issues are covered in the ADA, are recognized as a disability. And it doesn't have to be permanent. So maybe it's a period of time where it's worse than others. So maybe during his time with the working schedule and the thing, is activating or increasing his symptoms that he usually is able to control. So it doesn't have to be a permanent state that he's in. And it doesn't have to be so severe. It just has to be substantially up. It doesn't have to be as severe as substantially limiting. So it's not something that has to be in a constant state the entire time. Your symptoms, they can come and go. But what matters is how limiting they would be when the symptoms are present. So if he had like PTSD and, a lot of these work stresses are starting to kind of bring up his symptoms and stuff, the issue is, how is he feeling once those symptoms have been activated? And how is it affecting his work? When it comes to the ADA, your employer can ask you to submit a letter from your healthcare provider that you have a mental health condition and that you need an accommodation, but it's not required that your employer needs to know your specific diagnosis. It might be enough to just provide documentation that describes your condition, like more generally, like maybe you have an anxiety disorder, and that your healthcare provider can provide some particular accommodations that they think would help assist you in this situation. Also, there is a lot of guides available on the ADA website with an EAOC, which we'll get into later, that you can provide to your healthcare provider to help them understand reasonable accommodations and how they can assist you in getting those accommodations that you need. Okay, next slide. So under the ADA, these are just a quick list of course, not exhaustive, way more accommodations that can be out there. of kind of accommodations that people that usually are found to be reasonable accommodations. They don't cause too much of a burden on the employer. You know, access to water, having a water bottle, transfer to a different position, more shade, a stool to sit on during your shift, frequent rest breaks, breaks to take your medication, temporary relief from heavy lifting, or even improve accessibility in a work area. So in our example, John might be able to speak with his supervisor or manager, kind of explain that he's having these sleeping troubles and trouble eating, and he needs an accommodation at work to help him. Maybe he can request, which is on here, like a modified work schedule, so he can come into work later or work less overtime, or he needs more frequent rest or snack breaks. Those are sort of part of the conversation that John could have. And the next slide is, how do you kind of approach this idea of a job change or a job accommodation? One, you need to tell your employer that you need an adjustment for a reason related to a medical condition. Again, they may ask you, your health provider, to confirm your disability, but it's not always a necessity. It's not a must that your employer will say that. And then once you are informed, your employer that you need some adjustment for a medical condition, it is then the employer must begin an interactive process or a conversation to see if there's work options that can address your specific medical needs. If you notify your boss that you have an underlying medical condition and need a minor job change, they cannot ignore it. They must begin that interactive process. And even though you might not be able to receive your first accommodation choice, your employer has to provide you with an alternative accommodation or alternative change, and cannot force you to take unpaid leave if there's another option that can keep you at work. So really having a dialoguing conversation of what can make you still be able to do your job. Okay, so next slide is just a quick recap of what we discussed. John, again, he has a psychiatric disability, and because of that, he may be covered under the ADA. The ADA prohibits employers from discriminating against employees that have a disability and requires employers to provide reasonable accommodations unless it would pose an undue hardship on the business. In order to kind of get these job changes, John may be able to inform his supervisor or manager that he's having these troubles, you know, sleeping and eating, and that he needs a job change or accommodation to assist them. He can request things like a modified schedule where he can come into work a little later, maybe a reduced work schedule, or take more frequent rest and snack breaks. It's up to his employer to have that conversation with him, and they're not required to make the accommodation that you asked for, but they are required to provide you some alternatives, or at least provide a reason as to why it'd be too expensive or difficult to make any change to your job. Okay. Next, we're going to go into scenario 2. Jane works at a large fulfillment center in Alabama. She is 7 months pregnant. Jane has chronic back pain and must use the bathroom frequently, but it is not clear that she has a pregnancy-related disability under the ADA. What are her rights? And are there any changes Jane can ask for in the workplace to stay healthy while working? Okay, so Jane, the federal law that might apply in Jane's situation is the Pregnancy Discrimination Act. The Pregnancy Discrimination Act is federal law that prohibits the unfair treatment of workers because of their pregnancy, childbirth, or related medical conditions. Unlike the ADA, you do not have to have a pregnancy-related disability. This is simply unfair treatment because a person is pregnant or related conditions related to being pregnant that don't rise to the level of a disability, so that the ADA would cover it. It applies to employers that have 15 or more employees, and it prohibits the employer from discrimination against an employee in any aspects or of terms or conditions of employment. So this includes harassment, and it also includes hiring, promoting, firing. All of that's included in the job process. So Jane here could or may be able to request an accommodation using the PDA, but only if others are accommodated as well. And she's protected against discrimination because, or unfair treatment because she is pregnant. The PDA, it applies to employees that are pregnant, but it also may protect employees who are not yet pregnant or have already given birth. An employer can't treat employees differently from others based on their pregnancy. For example, if they cut a pregnant worker's hours, but not others, because that worker is pregnant, that could be pregnancy discrimination. And then also it's harassment. Harassment, it's illegal when it's so frequent and severe that it creates a hostile or offensive work environment, or results in adverse employment decision like being fired or demoted. Harassers can be, the supervisor, a coworker, or someone who's not an employee, like a customer. Now, with the PDA, you also have the ability, similar to the ADA, to request these minor job changes or accommodations to keep you working and on the job. For an employee who works, you have to have an employer with 15 or more employees. You may have a right, even if the worker does not have a disability associated with pregnancy. So as I said, it doesn't rise to the level of a disability as you would under the ADA. But related medical condition could include lactation. If an employer provides accommodations to other employees similar to a pregnant employee, but refuses to provide accommodations to the pregnant employee, that could be a violation of the law, and they would need to provide the employer with accommodation. So what this means is if they're able to accommodate somebody who maybe under the ADA has a disability and they need to use a stool, and then a pregnant employee goes to them and they would asking for accommodation, they're like, can I use a stool? They can't tell them no while they're also providing an accommodation to somebody else. That's sort of the gist of what that kind of sentence is getting at. So another example is if your employer provides smoke breaks in addition to meal breaks, they would have to provide a pregnant worker with additional breaks to go to the bathroom or eat snacks, to keep our iron or sugar levels consistent. Now, if she was certain that if she had a pregnancy-related disability, like high blood pressure, high blood sugar, again, that would be something that could be more covered under the ADA because it's a specific diagnosed disability. Okay, so just a quick recap. So Jane, as our pregnant worker, she may be covered with the PDA, the Pregnancy Discrimination Act. The PDA prohibits employers from discriminating against a worker because of their pregnancy or childbirth, and requires employers to provide reasonable accommodations if they were to provide them to other employees that are in similarly situated in their ability or inability to work. Again, they're providing accommodations for somebody else for them to do their job. They have to provide accommodations for a pregnant person to do their job. Jane, in her situation, she could request the use of a stool to assist with her back pain, maybe more frequent breaks to use the bathroom to prevent, urinary tract infections, et cetera, and stay healthy. And it should all happen if that employer is providing similar accommodations to somebody else. Maybe they get to use a stool because they have some limited back issue, or another person gets frequent snack breaks because they have high blood sugar. Again, they're providing accommodations for somebody else. They have to provide accommodations for a pregnant person. Next, I'm going to go into the EEOC, which stands for the Equal Employment Opportunity Commission. So we discussed both the PDA, Pregnancy Discrimination Act, and the American with Disability Act, ADA. This is the agency, the federal agency that's sort of put as an enforcement. So if your rights are being violated, you would go to the EEOC. The EEOC, they prohibits discrimination in any aspect of employment. Again, so it applies to hiring, firing, promotions, demotions, layoffs, etc. And discrimination can be based on a whole host of laws. We specifically talked about disability and pregnancy with the PDA, but there's also laws as far as discrimination, again, based off of age, equal pay, genetic information, information, national origin, race, religion, retaliation, sex, and sexual harassment. An employee has 180 days after the alleged discriminatory act to file a charge, but you might have more than 180 days if there's like a pattern of discrimination. So in these situations, maybe Jane, being a pregnant worker, her hours are cut, and she thinks it's because she is pregnant. She has 180 days from when they told her they were going to cut her hours, or from when they cut her hours, to file a charge to say I was being discriminated against because of my pregnancy. You can file charges with the EEOC in person, by phone, by mail, and online. And after you contact the EEOC, the examiner will schedule an intake interview with you. They will discuss your concerns, exactly why you discuss your complaint that you're filing, and they will investigate. EEOC will investigate your claim. They'll notify your employer that you filed the charge, and then your employer will be able to respond to that charge. There's a little bit more detail that goes into it. You might receive a right to sue letter. If you do, then you have 90 days to file a complaint in court. It gets more and more details as you go on, so it's really factor and situation dependent. But just wanting to highlight that due to the pandemic, some of the original timelines have been adjusted. So maybe it's not as clear cut as to the turnaround time for an interviewer to get back to you, or for a determination to be made that might be extended. You again, in these situations, because they're so factor dependent, it's really better to call and consult with someone. I know we have our hotline, free and confidential legal hotline, where somebody can help you and discuss this process and your rights if you have been discriminated against, or for your disability, or because you're pregnant. Also just want to make sure you know that in most acts of discrimination, a charge of discrimination must be filed before you can file a lawsuit for unlawful discrimination. So usually going through the EEOC before then you can file a lawsuit in court. And last, just a quick note that you can have somebody else or an organization or an agency file on your behalf with the EEOC if you need to protect your identity for some reason. Okay, now on to FMLA. The FMLA is the Family and Medical Leave Act. So this provides up to 12 weeks of job protected unpaid leave. So again, this is a situation where some injury, illness occurs and you just cannot work. The FMLA protects your job for 12 weeks of unpaid leave per year. And it can be used on a reduced schedule, or all at once, to care for yourself if you're injured, or a family member's serious medical condition. So a family member, it could be a spouse, child, parent. To be eligible for FMLA, as an employee, you need to have worked 1,250 hours in the year prior to needing the leave. You have to have worked with that employer for at least 1 year. And you have to have worked for an employer with at least 50 employees within a 75-mile radius. Let's see on the next slide. If you know in advance that you'll need FMLA leave, you must notify your employer at least 30 days in advance. If it's an emergency, you must notify your employer as soon as possible. Your employer cannot punish you in any way for taking or even asking for leave. And for the most part, your employer must return you the same or similar position after you've taken FMLA leave. You should always double check with your employer, of course, about their specific policies and how you can use paid time off, vacation time, or sick leave to actually receive pay if you're taking, if you have to take leave off your job. FMLA is different from a leave of absence, which may be provided through your employer. So again, you need to double check if it's a leave in absence, or if you're going to be using FMLA, or if you're going to be using some other type of paid leave provision. Some employers allow you to take them to use them at the same time, a combination of that vacation time or sick time and FMLA. But again, that's depending on your employer. And so you need to make sure that you ask for that. And in other situations, which I know some people are probably thinking about, there's other options if you don't qualify for FMLA, like workers' comp, and unemployment. Again, those are very specific to the situation, and you would have to follow those guidelines in applying for those programs. Okay, now for Department of Labor, we kind of jumped to Department of Labor, is that they're the ones that enforce that Family Medical Leave Act. So again, if you have to take that unpaid time off, instead of for the ADA and for the Pregnancy Discrimination Act, you go to the EEOC. For the Family and Medical Leave Act, you would go to the Department of Labor for enforcement. So the Wage and Hour Division of the DOL specifically is the one that enforces FMLA and other workplace laws. And it's committed to ensuring that workers are paid properly and for all hours worked, regardless of immigration status. In general, you have 2 years to file a complaint, or 3 years if the act was willful. Now, willful means they intentionally violated the law. They're saying, we're not going to allow you to do FMLA, we're not letting you use your rights. You know, that would be an example of something, a willful act. But again, between 2 years, if just a regular complaint, 3 years if it was willful. And just always wanted to highlight that your employer cannot terminate you or discriminate you for filing a complaint with the DOL or participating in an agency because of you filing a complaint or whatever the circumstances may be. And there isn't a particular form to complete for FMLA violations, but you can contact the DOL, Department of Labor, and they will provide you with information as to how to file a complaint if you're specifically filing one regarding the Family and Medical Leave Act. Just lastly, I want to just quickly touch on abusive attendance policies. It's something that, again, at ABB, it's something that we also are working against is, employers that have these policies that give points or, dock, workers for missing work, even when it is due to, a medical issue, or some having to take care of a family member or a child. And once you rack up these these attendance policies, these points, people are being terminated because they've run out of points or they've used too much. And again, these laws and these policies, they may violate your rights as an employee for the absences that you are given under laws like the ADA, the PDA, or the FMLA that we've discussed. So again, just wanting to highlight that as that is something that we're seeing. And if you are seeing a situation where you're racking up these points and you might be terminated or fired simply because you're using leave that you're guaranteed to under the law, that's an issue. And that's something you should definitely contact ABB about if that's something that's happening to you. Let's see. Next, this is just a recap slide. We did a lot of information in this webinar. I know it was a lot, but we're just going to put it down, distill it right here on this slide. Again, EEOC, Equal Employment Opportunity Commission. This is an agency that is enforcing those anti-discrimination laws. 15 or more employees. It can be race, sex, color, pregnancy, national origin, religion, etc. You can contact the EEOC and get more information at 1-800-669-4000 or visit eeoc.gov. And then the federal DOL, Department of Labor, they enforce Family Medical Leave Act, minimum wage and overtime, meal periods and break times, etc. Things that we didn't get to cover today. And you can contact the DOL at 1-866-487-9243 or visit dol.gov. Again, a lot of information, I know, but the more information you know, the more information you can share with others. The goal of this presentation is not for you to become an expert on all of this information, but just to know where you can go and know what resources that you have available. And again, at A Better Balance, we are here to provide information. And on our next slide, again, will show we have a workers' rights hub just at www.abetterbalance.org. It is divided up by state, so whatever state you're in. If you're not in Alabama, we have other resources as well. Shows you what your rights are, and then also we also have our, again, I'll say it again, free legal confidential helpline at 1-833-NEED-ABB. We're here to assist people, and if any of these situations are coming up or anything we've mentioned today is an issue that you're facing, please, we welcome your call and we're ready to help and assist you. Thank you. I think next we're going to pass it over to the one and only Charles.
Thank you so much, Lauren. A lot of great information you passed on. You too, Larry, as well. In regards to worker safety, both employees and employers are responsible for providing a safe and healthy workplace that's free from recognized hazards and likely to cause harm or death. With government regulations such as the Occupational Safety and Health Act, or OSH Act, the National Labor Relations Act, the Pregnancy Discrimination Act, and the American with Disabilities Act. These government agencies and others that Lauren had named earlier have laws that covers all workers within the United States. As an employee, being familiar with the coverage that these government agencies provide workers for safety matters. So if your employer don't seem to be too interested in your safety, you have the right to speak up and make your concerns heard in the name of safety. By following the guidelines from today's training, this gives us an understanding of what to look for, preventing workplace injuries, illnesses, and stress. And let's not forget, if you are injured on the job and you don't have vacation or emergency time, you can still be qualified under the Family Medical Leave Act, as Lauren discussed earlier. By offering these worker rights trainings, our goal is to inform workers on federal protections and rights when it comes to health and safety. This information can help you become a better advocate for yourself and your coworkers. So if you find these trainings useful, please share our contact information with your coworkers, family, and friends. And now on to my call for action. Knowing your rights equals self-empowerment. I'm going to ask you to make the effort to improve your individual working conditions, especially if you see a lack of standards within your workplace. You can start by using your voice to improve conditions for yourself and others. And if you have any questions about today's webinar, you can log on to alabamaworkers.org. There you can submit your questions if you haven't asked them today, or to just get in touch with the folks on the webinar here to give you assistance with any questions that you may have. And also, check out our Facebook pages. A Better Balance is on Facebook, as well as Jobs Move America South. And our partners are there as well. So take a look and see some of the work we're doing. Thank you. I'll pass it back to you, Larry.
Thank you, Charles, and thank you, Lauren, as well. This has been a really good webinar. I think it was a lot of good information, and I hope you have heard something here that's going to help you advocate for yourself and your co-workers on the job. We always want you to make sure that you learn something, that you walk away from these training webinars with more information that can help you stay safe and to advocate for your rights. We want to thank you again. If you have questions about how to request accommodations, or if you're pregnant and you have a disability, paid or unpaid sick time or family leave, or your rights during COVID-19, you can contact A Better Balance. A Better Balance South office, you can call them at 1-833-633-3222. That is for free and confidential legal helpline. Or you can log on to abetterbalance.org/states/Alabama. Also, Jobs to Move America South program, the number is area code 205-612-3722. Or you can contact Adelante, Alabama Workers Center, 2104 Chapel Hill Road. Adelante, Alabama Workers Center, United Day Laborers domestic workers and other low-wage and immigrant workers and their families in the Birmingham area to defend their rights, promote their dignity, and to pursue justice for all. At Jobs to Move America, we envision a South where manufacturing jobs are good jobs that offer good wages and benefits, and that companies commit to hiring goals for marginalized communities, including women, people of color, and people who face barriers to re-entering the workforce. And I would like to just thank you once again and invite you back. Next month, we're going to have another one, and we're going to try and stay on schedule this time. It's going to be the third Thursday of the month. And again, on behalf of my cohorts, Lauren Booth and Charles Crooms, we thank you all for joining us and hope you have a great day. Thanks. Bye, everybody. All right.